Right, hi people. This is LAWS12066 Land Law, and this is a feedback recording for the 20% assessment, which has recently been returned. So this assessment was worth 20 marks, and it had two parts: part capital A and part capital B. Part capital A was a problem-solving exercise based on a scenario, and it was divided into two parts, small a and small b. Second major part of the assessment, capital B, was really technology skills, legal technology skills component, where you were required to undertake the completion of the national mortgage form with supplied information both from myself and also as supplied by PEXA, to be completed inside the electronic conveyancing PEXA learning environment through a collaboration that CQ has with PEXA, which I facilitated. That was worth 3 marks, and then there were 3 marks for an evaluation and reflection on that experience, and also on your comments in terms of Queensland moving towards a mandated electronic conveyancing environment, which currently isn't the case in Queensland. So coming back to capital A, the scenario involved a mortgage transaction, which is evident, and there were Graham and Teresa, who were the registered proprietors of a property in Queensland, in Townsville, and they owned the property outright. It wasn't, there was no security interest over the property or encumbrances on the property as revealed by the facts. And Teresa wanted to, or rather Teresa and Graham had undertaken in the past decisions together in regard to developing an investment portfolio, and they had been involved with Sunday Island Bank previously in these investments and getting funding for those. So there was a relationship between Graham and Teresa and the bank, WIB. Teresa wanted to pursue another business opportunity, discussed it with Graham, and Graham was a bit reluctant, not sure about this, hesitation. Anyway, Teresa basically said, look, I'm going to go ahead with this, and I deal with legal matters mostly anyway, so I'll talk to the bank. Teresa takes herself off to the bank, sees a loans officer, fairly junior loans officer, Tim. They talk through the matter. Tim says, oh, well, there's some procedures I need to now follow. And Teresa sort of tries to sidestep that a bit and say, well, look, you know, we're existing customers of the bank, long relationship with the bank. Going to make things difficult for me. I can take our business elsewhere. Tim basically seems to buckle at that point and says, okay, fine, that's right, we'll deal with matters. Critically, of course, Teresa reveals that she has the e-signature of Graham stored on her phone. She's happy to get Graham on the line by FaceTime. That doesn't actually happen. Tim says, no, that's fine, we'll just deal with this matter. And then in the end, the documents are forwarded to the bank solicitors, who then forward them to Graham and Teresa's solicitors, and they're sent forward to Teresa for signing. She then signs the document, signs the mortgage, signs the loan contract. She does that and applies her signatures, and also applies Graham's electronic signature, which she has. And the mortgage is registered. Okay, and then Graham becomes aware of this after gets a letter from the solicitors saying, well, this has happened and so on. Very unhappy about that, didn't agree to that. And what can he do about that? That's basically small a within capital A. How can he challenge the registered mortgage interest of WIB? Because the facts reveal it's been registered. Part B is about advising the bank, WIB, there's mortgagee. So basically what the questions are asking me to do is to investigate how Graham can challenge the registered mortgage of WIB, the bank, what might be the basis. And essentially, what you're looking at there is the fact that registration gives indefeasibility to the bank. So you needed to just explain that. You needed to then say, well, despite indefeasibility, which gives certain level of protection, of course, to the registered interest holder, how could that be challenged? Well, of course, one of the ways straight up is that could you argue there's an exception to indefeasibility? And of course, the most direct type of exception, which the facts toss up, is the potential for fraud, the fraud exception. Some students tried to argue, the in personam exception or personal rights exception. Happy to see that through, trying to argue unconscionability, but really the main type of exception was the fraud exception. The challenge here, of course, was that it's not fraud committed or fraud proven by Teresa that is what needs to be established. It has to be fraud that's brought home, according to the relevant case law, brought home to the registered interest holder. And of course, that was the bank, WIB. So what students needed to do was to look at the facts, scrutinise the facts carefully. How could you link the chain of events in relation to establishing fraud being brought home to WIB? Well, you could certainly talk about Teresa's actions and so forth. Well, students made assumptions about the fact that she had the e-signature, so therefore necessarily she was being fraudulent or she was being malicious or whatever. No, you can't just assume that. You have to investigate the facts and you have to establish whether that is the case. I mean, the facts reveal that Graham and Teresa have actually been involved in investments in the past. And even though they're siblings, it would appear, as I commented on many students' papers, that arguably they're business partners for the purposes of making investments. So in that context, the issue of authority services, and there were many students picked up on that point. A few students also picked up on the authority point in regard to the actions of Tim, the bank employee, as an agent of the bank, and that was not inappropriate. But you could argue that, at least putatively, that Teresa had the authority to act and conduct things in the way that she did. Now, that needed to be just investigated and not just assumed. That's the point that I want to make there. But then you had to draw that link to dealings that Teresa had with Tim, Tim's conduct. He didn't assiduously go through the process. He seemed to, once he got under pressure from Teresa being an existing customer and the threat of taking business elsewhere, he seemed to buckle to that. So the issue there is, well, but could you argue that his conduct, his decisions in conjunction with Teresa amount to fraud? So the point here is you needed to look at what fraud what fraud requires under the LTA, and the case law, of course, indicates the test is that you need to have personal dishonesty, or this opaque idea of moral turpitude, whatever that means today in the modern period. But personal dishonesty, I think, is the good modern understanding of the test. Look, challenging to establish that you can bring that home to WIB at the end of the day, I think, but that needed to be investigated, and also the issue about whether Teresa was Graham's agent. Also happy to see arguments about agency with regard to Tim and the bank, because of course an employee can be an agent for those purposes, and how that was able to link that back to establishing whether the bank had actually committed fraud according to the LTA. And that required, of course, an identification of the legislation as well as the relevant case law and a resolution of that. The next issue, really significant issue, was in relation to the process that was followed in terms of setting up the mortgage. And this actually related to the verification of identity process, which is now found within the LTA and also the Land Title Practice Manual, because the standard is there in the Land Title Practice Manual, whereas the requirement is set up under the legislation. A percentage of students picked up on that. There's actually been some recent case law on this, which was good. looking at that. The truth was that the facts were not actually on all fours with any case that you've looked at. So this seamless application of the case law was something that I was looking to see to what extent had you picked up on that point. How could you argue the law into this factual scenario, which actually wasn't identical? Because many of the cases deal with people in a spousal relationship or a de facto relationship. Well, Graham and Teresa weren't in that sort of situation. In fact, their relationship was actually probably quite similar to the Casa-Graham situation, except that the situation there it wasn't exactly the same either. The siblings aspect was the same, but they weren't. The brother and sister in Casa-Graham weren't business partners. But so there was that aspect of it that needed to be looked into. Were the VOI requirements satisfied? If they weren't satisfied, now this was looking at it from the perspective of Graham. So Graham's trying to argue that they weren't satisfied, and that would then actually make the mortgage feasible, and that would be a good outcome for Graham. And then when we get to small b, that was important to look at that aspect from the bank's perspective, because they'd be seeking to argue, well, we have met the standard around the reasonableness standard and so on. So the VOI issue was there. It was also important to identify the fact that the factual situation was in an environment of electronic technology. So documents were electronic. Did we have a full electronic conveyance? The fact that documents had been sent to the clients for signing would suggest no. There was no client authorisation document on the facts, none in evidence, none in the fact that it had been signed off. Documents hadn't been completed inside PEXA, so it really wasn't in the scenario, this is opposed to capital B in terms of the skills exercise. In the scenario, this capital A, it really wasn't a full electronic conveyance. But look, I was happy to let people pursue that idea and investigate the aspects and features of the facts, and that's really what I was looking for. The point was, how does the body of law, the case law that is really mostly around, if not almost all, around paper-based transactions, how can you apply it into the context of transactions in the electronic environment? And that's really something, the skill, like that's an important takeaway from this assessment, because that's exactly what has to happen now in reality. We have to ask that question: how does this body of law decided in this different in context get applied into the electronic environment? It does have relevance, but we need to highlight the differences. And so I was looking for some identification of that. You could have also brought up in the first part of capital A about the loan term and how that was linked to the sum secured in the mortgage. That also became relevant in small b from the bank's point of view in terms of enforcing the obligations against Graham. But they could have also been raised in A. Happy to see students do that, but I gave a bit of latitude there for students in terms of where they decided to bring up that issue. So those first three issues were the significant dimensions of Part A, that is indefeasibility, exceptions to indefeasibility, VOI from the perspective of Graham in terms of trying to say that they hadn't been followed and therefore that would affect the degree to which the mortgage would bind him, and then also to some degree you could raise the loan contract and secured sum dimension in terms of the nature of the mortgage. I'll just come to that again a bit when I discuss small b, and also the context of the facts and how we apply the law into that electronic environment. Okay. In terms of small b, the main issues really there were again around around VOI, verification of identity, this time from the bank's perspective. So the purpose of this first part was to get you to look at it from both sides of the transaction. As lawyers, we very often think from the perspective of acting for a private client, but we may well end up working and advising, for example, in this context, mortgagees. So how do we look at those legal requirements from the perspective of the mortgagee? How do we look at the VOI requirements from the perspective of the mortgagee, trying to say, yes, we have satisfied those requirements? Don't forget the standard in the Land Title Practice Manual talks about what's reasonable. One of the issues, of course, that came up was the fact that Graham wasn't a party to these discussions, assumedly, and how do you then satisfy the face-to-face dimension or requirement? Now, the FaceTime link was offered, but it didn't actually take place. Better Answers identified that. The question was, could the bank argue that they had, undertaken reasonable steps to fulfil those obligations? So looking for that sort of analysis against the facts, and again, probably difficult to argue, but how would that be mounted? Also, the actions of the solicitors. How did their actions relevant in terms of satisfying VOI requirements? Certainly the documents just seem to have been sent on and no checks or whatever. And so what are the obligations there, and how do they link to what the bank itself is required to do through its officers or staff? Again, Better Answers picked up in this dimension the idea of, well, does it make a difference that there's an existing relationship, business relationship? No, it doesn't. And again, that's within the framework of the regulations. So that was a significant aspect to small b. The second, really, the other significant aspect to small b was about the loan term and looking at the nature of the mortgage facility. Was it a facility mortgage or was it an all monies mortgage? In fact, it's interesting that not very many students actually labelled this difference between facility mortgage and all monies mortgage, even though the casebook clearly talks about this dimension. But many students explored that feature of, well, what did the loan actually secure in terms of the mortgage, and what if the mortgage, what if the loan contract was unenforceable because problems in the way that it was finalised, and yet we had this indefeasible mortgage. And then there was wording, of course, provided in terms of the sums secured and those that were present. And that wording was, again, not exactly on all fours with the case law that had appeared, but, again, Better Answers looked at that case law, explored that case law in terms of what was actually secured and the effect in terms of when, for example, the loan contract couldn't be enforced and you've got a registered mortgage. So that was really that dimension of the question. Some students just, chose also in that part to further go into look at the exceptions to indefeasibility, and that possibly you could have, certainly have a look at that as well, but that was really more in terms of the arguments that Graham could have brought. So capital A was looking at the idea of indefeasibility, exceptions to indefeasibility in the context of a mortgage instrument, the idea of how can a registered mortgage, what does the indefeasibility extend to include? How can you attack that registered interest? Exceptions to indefeasibility in mortgage situation in particular, even though the law of mortgages wasn't actually relevant. We then have to look at, well, what does the indefeasibility extend to include? How do we then link that back to the loan contract, which happens contemporaneously with the mortgage? So the loan is, creating the lender-borrower relationship, and the mortgage is the mortgage or mortgagee relationship, and the security interest that the bank has. Very important to understand that in a Torrens mortgage, the mortgagor, who was the owner of the land, in this case, Graham and Teresa, they continue to be the owners, they continue to be the registered proprietors of the land. What the bank gets, what the mortgagee gets, is a statutory security interest over the property that is defined and governed by the legislation, and today also by the accompanying regulations and case law that explains and interprets that for us. unlike in old system mortgages, which we will just touch upon in our last topic in this unit on the law of mortgages, where there was a conveyance, then a reconveyance of the property when there, a conveyance when the mortgage was taken out, then a reconveyance when it was paid off, if you like, following some intervention by equity. That's not the case under a Torrens mortgage. The mortgagee never gets the legal interest. They get a security interest under the Torrens Act. Having said that, of course, once registered, it's an encumbrance on title, and most mortgage instruments will specify that the owner of the land, the registered proprietor, shouldn't do things unless the mortgagee has been advised. And so there are restrictions to some degree on what the registered proprietor can do where the land or the property is encumbered by a mortgage. So again, the purpose of that exercise was to get you to explore the indefeasibility, exceptions to indefeasibility, the new verification of identity requirements within the electronic environment, to look at a scenario that involved electronic features, but also to ask, well, is there differences between a full e-conveyance on the one hand, or a process undertaken through a full e-conveyance, and a process that the documents are electronic, but it's not actually subjected to a full e-conveyance administered through the PEXA electronic workspace. Right, and there was some, really good work done on part capital A, some very positive work done in regard to that, which was pleasing, and most students got good results, or very solid results in regard to that, which was good, and I was very pleased with that. When we came to capital B, then again, small a was about completing the national mortgage form. Now, there were two bits to this, right? It was clear in the instructions, okay? So you're required to complete the national mortgage form inside the PEXA learning environment through the PEXA website. Students had a few IT issues with that, but most people were able to navigate their way through it. There was, I'd put on the website, on the Moodle website, the PEXA materials to explain the process and the things that were needed. And then further information was provided to complete the form. So that was basically to give you the experience of seeing that, both in terms of the fact that we now have a national form for mortgages in Australia across jurisdictions, even though we don't have mandated electronic conveyancing in all jurisdictions. So in those jurisdictions where it isn't done as an electronic conveyance, then the electronic version of the national mortgage form would get downloaded and then signed and executed in the usual way, and then scanned in and uploaded, and then so on. Because in Queensland, of course, things get submitted electronically, even though it's not done through the electronic workspace administered by PEXA. So that was to give you that experience. And, almost all students successfully completed that, but there was a further dimension, and that is you were asked to give thought to including an additional term with the sum secured by the mortgage. And again, most students, the large percentage of students did that, recognised and inserted a term, and that was good. And the bulk of students ended up getting, almost all students got between 2 and 3 on that, out of 3, by satisfactorily completing the NMF inside the PEXA learning environment, and also adding an additional term with regard to the sum secured in the mortgage. The last part of the assessment related to your reflections on both your experience in doing that and also on moving towards a mandatory electronic conveyancing environment in Queensland. And again, there were some very interesting reflections there, and I'd say it's a fair point to make that a significant proportion of students were in favour of moving towards a mandated electronic conveyancing environment, which is it's interesting, and that's, I dare say, the future. There were certainly students that were concerned about that and made observations and comments about the risks, about the need for training, about a range of matters that would be reasons why that shouldn't be the case. So that was good, and there were some very good reflections there. I was also looking for a little bit of, reference in terms of the debate around what's going on, particularly with regard to, mandating electronic conveyancing. And I've actually given you some resources on the website in relation to that, a report, the review of the electronic conveyancing national law is on the Moodle website. So I was looking for that as well. And so to get a rounded, reaching 3 on 3, you needed to share your experience in completing the form. You needed to give your reflections on moving towards mandated conveyancing, and also include a reference at least to support that. Look, just some general comments in terms of the assessment. I've given feedback throughout the assessment. I didn't give a summation feedback at the end, and I think some students probably would have liked that. And I'm going to give some other options for feedback for the 30% assessment, and I'll send a note, an email out about that, just to respond to the fact that students would like that sort of overall summation feedback. So the nature of this assessment, I thought, was more appropriate to give comments throughout your responses, and then to give a statement at the end of each part. Some very, as I said earlier, some very pleasing work in this assessment, which was good to see. I hope you found the, in capital BA, completing that skills exercise useful. I certainly personally believe that it's an important skill going forward for lawyers to understand the electronic environment and to have an awareness of it and to build those skills. So I hope you found that valuable. And the exercise was also designed to not only get you to, to test the usual problem-solving skills that are really important, of course, but to apply it into the electronic environment of land transactions and land instruments, which is the reality today. We can't go backwards, people. Even though we don't have in Queensland full mandated electronic conveyancing, we have electronic documents, and we communicate as lawyers with each other electronically. We communicate with our clients electronically, and that's the world we inhabit. So we need to understand how the law, the legal framework, applies in this evolving context of transactional reality, if I can put it like that. And that's only going to continue, and that's something that you need to be mindful of and to be aware of going forward. I'm going to offer another couple of opportunities for further feedback on the 20% assessment if students are interested in that. And I'm going to offer that, and I'll send out an email about that a bit further time after the class in the tutorial in week 8, and also some extra time on the following Friday. Also be aware that I have extended the due date for the 30% assessment, and so that is the revised due date is now Monday, 16th of September at 11:45 p.m. I think, on reflection, I thought the tight turnaround between the release of results on the 20% assessment and the submission of 30% assessment justified that. So I hope that that's of benefit to everyone. Certainly, if you finalise the assessment and you want to submit it, please feel free to do so. I think a few students have already done that according to how they arrange their commitments and time and so on. But all students, without penalty, have up until Monday the 16th of September, 11:45 p.m. to submit the next assessment, the 30% assessment. I've also uploaded instructions, student instructions, put it like that, for the final 50% exam. I'll be doing a recording on the exam shortly, not immediately, but shortly, just to give you a bit of a heads up on thinking about the exam, which hopefully will be useful. Plenty of opportunity in the consultation sessions to ask questions about the exam, and I will respond to those as appropriate. And in the instructions, I give clear guidance as to the topics that are being assessed and the structure of the exam and so on. So hopefully that's all good, and hopefully I'll get up a practice paper sort of in the next week or so for you as well, and we can keep soldiering on. So there we are, folks. Feedback on the 20% assessment in land law. Okay, bye for now.